Hello, everyone. Hello, everyone. What a day! What a day! What a day! What a day! I'm gonna wait a few minutes for people to get in here. And then I still I want to post the clip of Steele's actual sentence. So I'm gonna do that here. I've got the "You've been sentenced" clip here. I messaged Doug Weinstein too. I sent him the link to see if he happens to have a chance. I don't know if he's gonna have a chance, but he just messaged me back a photo uh, that here I'll share it. It's Steele, and apparently we're talking about the Young Thug case and Brian Steele's contempt of court arrest today because he technically was in custody for a short period of time. He's not going to jail tonight, but the judge did order him to go to jail for 20 days starting this Friday at 7 p.m. He's got to go on the weekends. So this is outside the courthouse. A few minutes ago, I got this photo from Doug Weinstein, who is Diamante Kendrick's lawyer. That's Young Thug's co-defendant. He goes by Yak Gotti. He's signed to the YSL label too, but that's Brian Steele. And apparently there were so many defense attorneys who showed up at the courthouse to represent Steele, but he had Ashley Merchant, and I don't know off the top of my head the other guy's name who argued for him, but Ashley Merchant is the president of the Georgia Criminal Defense Attorneys Association, and she got famous because she is the one that blew open the Fonnie Willis scandal, and got profiled in the Wall Street Journal and did all that argument. She represents one of the Trump defendants, but she was the one who argued for Brian Steele today. And I definitely don't think we've heard the last of this, but let me play. Let me get to the clips this morning of kind of where this all started, because it was, I mean, the trial never starts on time, right? That doesn't surprise anyone when the trial doesn't start on time, but it usually doesn't start 2.5 hours late. I mean, it was like, I'm thinking in West Coast time because I'm here in California, but I mean, it was supposed to start at 6 a.m., 9 a.m. Atlanta time, and it was like, what was it, like 11:30, and they finally got going, and we were hearing all these rumors about what actually was going on. But we finally heard from Steele. Steele found out from what happened. So here, I'm going to turn this.
Can I interrupt you just a second? I'm kind of team, to my knowledge, was aware that this was going on. It was told, based upon information belief, that it was told to the district attorneys that Mr. Copeland intended to plead the Fifth Amendment. Then I was told, based upon information belief, that Adrian Love, the lawyer for Mr. Copeland, and this court were together, and Ms. Love made representations that John Melnick supposedly spoke with some attorneys for the accused and wrote an email to Miss Love, to Adrian Love, stating that Mr. Melnick does not represent the witness, and that Mr. Melnick wrote an email saying F you, and then somehow that email was CC'd. To me, that never...
Mr. Steele, can I interrupt you just a second? I'm kind of disturbed because that's ex parte. All that was an ex parte conversation. How did you find out about any of that?
Well, I'm disturbed too. And the reason
I'm asking you a question. How did you find out about it?
I'm going to ask you the question.
Okay.
Scuttle, if you look at SCUDDER versus State, which is 298 Georgia, 438, it's Division 2, 782 Southeast 2D 638, 2016. Our highest court says when a court meets, because Mr. Copeland comes in, meets with the court supposedly made statements, which I assume is somewhat accurate based upon what you just said. We're entitled, Mr. Williams and every other person wrongly charged here is entitled under the Georgia Constitution to be present. That's a critical stage.
It's just like when you meet with me and you and Mr. Adams meet with me and others have met with me. It's those were ex parte for a lot of different other reasons, but I will certainly note that for purposes of record.
Well, I'm going forward. What I was told was that Mr. Copeland said,
and you haven't answered my question yet.
I'm not going to answer that question.
You're not?
No, I will not answer that question.
Why will you not answer that question?
Because I want to make sure that what I say is accurate, and I'm not trying to
No. I'm asking you, how did you get this information?
I'm not telling the court. What I'm saying is based on information.
Okay, well, listen, if you don't tell me how you got this information, then you and I are going to have some problems.
We can have I have problems right now.
Okay, I know. Look, I don't want to know about your problems. Okay, at this point in time, all I'm asking you at this point in time is, how did you come upon this information? Look, if the case gets reviewed, the record's going to be available for our appellate court and for whatever reason. But it's disturbing that how somehow you have surreptitiously gotten information in regards to the court's private ex parte conversation with a party. I mean,
a witness who was sworn in Friday, the court's telling, this is what I was told. If this is not true, not true. This court handed Mr. Copeland.
Tell me how you got the information.
Listen, whatever you want to do.
Tell me how you got the information, then we can go ahead and go forward.
I'm not going to say that. What I'm going to say is this. I was told, and I hope this concerns the court.
It concerns me that you have proprietary information.
Why is it
proprietary? Or information that you should not be having that was ex parte.
Why?
With a party.
Why?
State of Georgia.
How about the witness? How about Mr. Copeland, who supposedly announced he's not testifying and he'll sit for 2 years, and then supposedly this honorable court, or excuse me, let me rephrase that. This court supposedly said, I can hold you until the end of this trial. Ms. Hilton supposedly said, actually, all of the defendants and then all 26 people are disposed of. If that's true, what this is coercion, witness intimidation, ex parte communications that we have a constitutional right to be present for. So I understand that you're upset towards me, but I don't know what I did.
Mr. Steele, I still want to know, how did you come upon this information? Who told you?
What I want to know is, why wasn't I there? Why,
sir? I'm going to hold you in contempt if you don't tell me who tell me who this information was.
I don't want to be held in contempt. Well, I'm not answering that question. That's attorney-client privilege information. I am not
attorney-client privilege. Unless you were in my chambers, that's the only way you can figure out.
I
tell you what, I'm going to give you 5 minutes. If you don't tell me who if you don't tell me who it is, I'm going to put you. I'm going to put you in contempt because that is not attorney-client privilege.
Attorney work product privilege. I am not.
How did you get that information supposedly from my chambers? Did somebody tell you?
I'm not. You should have told me.
You got 5 minutes.
Well, I don't need it. I want to continue.
You got 5 minutes?
This is what I was told. Mr. Copeland made statements that he admitted to killing.
You all are really getting yourselves cross purposes at this point in time. Sir, I'm telling you, you are at this point in time. You made some things out of nothing. I think that you're on very precarious ground at this point in time. So I'm telling you at this point in time, he's in custody. We're going to go ahead and start. You can represent Mr. Williams. That's okay. That's fine. I'll take up the other stuff as needed, but I'm not going to take it up right now. Say again? Respectfully, I will not. I cannot. Sir, you have to. Well, you're gonna have to do the best you can at this point in time, because you don't get to extort the court. That's what you're attempting to do at this point in time, sir. Yes, you are. What you're trying to do is, I'm not going forward if I don't get this. You know, it doesn't work that way, Mr. Adams. And I'm telling you at this point in time, I would just kind of govern yourself accordingly, sir. I'm telling you, as the court, under these particular circumstances, everything will come out as it should. I don't think, sir, I don't have enough information at this point in time to address it. I don't. But I'm telling you at this point in time, there is nothing that was given, said, whatever this morning that.
If there is any accuracy to some of the information that we are.
But sir, I don't even know. Your co-counsel won't even tell me who said whatever. Okay. And the challenge I'm having in this particular circumstance is that is such a violation of the sacrosanctness of the court's chambers and an ex parte conversation. You're just glossing over that. You're glossing over that in its entirety. No, it's not, sir. That's not in custody. And once he's clears the area, we'll go ahead and get started.
If by that point we get started and resume the trial, Your Honor.
Yeah, we're going to continue. I'm not caught nothing.
I'm not going to participate in trial without the stealing.
You don't have that luxury at this point in time, sir. You don't. You don't have that luxury. You don't have that luxury at this point in time. You don't. Sir, you all are really getting yourselves cross purposes at this point in time. Sir, I'm telling you, you are at this point in time. You made some things out of nothing. I think that you're on very precarious ground at this point in time. So I'm telling you at this point in time, he's in custody. We're going to go ahead and start. You can represent Mr. Williams. That's okay. That's fine. I'll take up the other stuff as needed, but I'm not going to take it up right now. Say again?
Respectfully, I will not. I cannot.
Sir, you have to. Well, you're going to have to do the best you can at this point in time, because you don't get to extort the court. That's what you're attempting to do at this point in time, sir. Yes, you are. What you're trying to do is, I'm not going forward if I don't get this. You know, it doesn't work that way, Mr. Adams. And I'm telling you at this point in time, I would just kind of govern yourself accordingly, sir. I'm telling you, as the court, under these particular circumstances, everything will come out as it should. I don't think, sir, I don't have enough information at this point in time to address it. I don't. But I'm telling you at this point in time, there is nothing that was given, said, whatever this morning that.
If there is any accuracy to some of the information that we are.
But sir, I don't even know. Your co-counsel won't even tell me who said whatever. Okay. And the challenge I'm having in this particular circumstance is that is such a violation of the sacrosanctness of the court's chambers and an ex parte conversation. You're just glossing over that. You're glossing over that in its entirety. No, it's not, sir. That's not what happened. That's not what happened. I'm just telling you, that's not what happened.
Judge, respectfully, we are not obligated to simply accept that there's been no violation. We believe that there has been. And the only
okay, well then no, we're not doing that at this point in time. So you'll have a choice to make. All right, take Mr. Steele into custody, please.
There we go.
In a word that you do take into custody in caution.
Your Honor, would the court afford me one moment to confer with counsel regarding the appropriate remedy in this type of
Okay, all right.
May I say one thing, Your Honor?
Yes, sir, you certainly may.
Mr. Williams does not wish to go forward without me being here. You are removing me against his will, my will. You're taking away his right to counsel. And you're conducting material parts of this trial without me present, and I can't learn about it by watching online. So for that reason, additionally, I asked for a mistrial. And I assume you deny, but I'd like you to deny our motions for mistrial. You denied the other people.
I've denied your motion, but I'll certainly take that under advisement, sir.
Case all for all those reasons.
We're going to be in recess for the next 5 minutes.
So, yeah, and now I'm still working on
All
the
right.
clip, but
Do you know someone by the name of Shannon?
Steele asked if he could be cellies with Young Thug so they can work on their case. But you see if Doug Weinstein's around. Doug, is that you? Are you able to join us right now?
Yeah, I'm here. Can you hear me okay?
Yes, we can. What a day in court. How are you guys all doing?
It's been a long day. I think we were fortified to see so many brothers in the criminal defense bar show up to give their support at the end of the day today. So that was very nice. But
Yeah,
what
we saw two at the lectern there with Steele, but there were many more there. It sounded like that all showed up at the courthouse. How many were in the courtroom?
Well, there's a limited seating in the courtroom, so I think probably maybe a dozen were able to make their way into the courtroom, and then there were another, I don't know, 15 or 20 outside. I'd say we had between 25 and 30 criminal defense attorneys come down to show their support for Brian, which he's certainly earned over the years.
Yeah, it sounded like quite a showing from the criminal defense bar, and it was a real kind of cliffhanger about what was going to happen. I mean, we knew that Woody was going home, but I told people we know Woody's going home tonight, but we're not sure about Brian Steele. But he did walk out of the courthouse, as the photo shows, because he's going to report Friday at 7 p.m.
Right,
So
that's what the judge ordered. So we'll see what it eventually ends up happening. You know,
Yeah,
in
because
this case, it's hard to predict what's going to happen tomorrow, let alone Friday.
Right. I was confused about the appeal because I thought Judge Glanville had said pretty confidently to Brian Steele that he couldn't appeal this, but there's a notice of appeal filed now. But it just seemed like there was a lot of confusion amongst the judge about civil versus criminal. I mean, he had to take some time to kind of review that and make sure he had everything. But is this appealable? I mean, is there a chance that the appellate court is going to step in and Brian Steele's not going to have to report to jail on Friday?
Well, I don't know. I'm going to leave that up to the brilliant minds that have been assembled or that have come together to work on an appeal. So
yeah,
I certainly trust their knowledge, and they believe it's appealable. So I would defer to them.
yeah, that sounds.
But
as of now, he's in court, and it seemed like even the prosecutors were showing had some questions about Glanville's approach, because DA Love actually urged him to make it so Steele could still represent Young Thug in trial. They were concerned about the representative issues, weren't they, earlier today before this all came down?
I'm done giving them the benefit of the doubt at this point, and to the extent she did that, I think it was to facilitate continued movement in the trial rather than to provide any sort of assistance for Brian Steele.
Yeah, that's probably true. I mean, she made clear that they supported this contempt thing, but they're worried about the length of the trial, I think.
And it's just insane how the allegations that we learned of today prior to returning from the lunch break of certain actions by the judge and the prosecutor have now been turned around to be all about, how did we learn this?
Yeah,
Instead of focusing on the extraordinary allegations that, or extraordinary conduct that we learned about today that Brian was trying to put forth before the court, and the judge was having none of.
Right, and we where Brian laid all that out. But I mean, this was an in chambers meeting. This was the whole reason that court was delayed. 2.5 hours this morning, right?
Apparently, but we were left completely in the dark. Nobody said anything to us. We were there at 8:30 as required by the judge, and not a single word was said to any of us about why there was a delay. We were left to, guess as to what could be happening. And so a certain lack of respect shown by whoever was involved in not giving us any kind of indication as to what was going on. And then learning about what was happening in chambers was nothing short of shocking. And I don't think Brian was even able to get all of that on the record today. Oh, I can't hear you now.
Hearing all this stuff about revealing sources, it's as a journalist, it definitely hits home. But it seemed like what Ashley Merchant was arguing this afternoon was that this isn't something that Glanville really has jurisdiction or power over. Is like the issue of who told Brian Steele this. Is that is that how? Is that an argument you heard this afternoon?
Yeah, I was sitting right next to her while she was making that argument, and that's my understanding of her argument.
Yeah. How can you hold somebody in contempt for not telling you something that you don't have jurisdiction to make them tell you? It seemed like she was.
And that's a small issue. The bigger issue is what happened in chambers, and what on information and belief was learned by the defense counsel occurred. Those are things that directly impact this witness and our abilities to cross-examine this witness. And I do not understand why we cannot get the transcript that we need that likely has Brady material in it, that's directly relevant to our ability to cross-examine Kenneth Copeland. Why keep this hidden from us?
And that's what Max Shard raised this afternoon before they left, was that they want the transcript of that, the court reporter's transcript of this in chambers discussion happened to be released before cross-examination begins, or they're going to be very hindered. But what strikes me is that there's such a lack of recourse for them other than just asking Judge Glanville, and if he says no, then it's just an issue for the Court of Appeals later on. They just kind of have the defense team, and same with the prosecution when he rules against them. There just isn't much they can do other than continue on with the trial. Is that how you see it?
It's a difficult situation, and there's limited avenues to try to get this remedy during the trial, and I think the judge is aware of that.
Yeah.
But again, why are we left to the proffer of ADA love? If there's nothing there, show us the transcript. And based on what we learned, there's something there.
Yeah, because I've said in some posts that when they talk about Brady material, and Max Short specifically talked about Brady material, and for people who don't know, Brady refers to Brady versus Maryland. It's a 1963 U.S. Supreme Court case that says anything that could be considered exculpatory evidence for the defense, if the prosecution has it, they need to release it. So something like this, like if what Woody said in that meeting with them potentially could be considered exculpatory. But of course, kind of one of the problems with Brady, like Brady complaints are the biggest complaint that you hear from the defense, or the most common complaint you hear is Brady violations, because it's kind of just up to the prosecutors to decide. But here we have Judge Glanville, who is also hearing all this stuff. So it's kind of on him. He has a big responsibility here if, depending on what Kenneth Copeland said in there, but there's rumors that he, talked about his involvement in Donovan Thomas's murder and things like that. And anything like that would be considered Brady material. I mean, would you argue anything like that as Brady material?
I would. Yeah, I think we all would argue that that's Brady material. Plus, Kenneth Copeland gave a half a dozen statements with many inconsistencies throughout. And so almost anything Kenneth Copeland has to say to, whether it be the judge or the prosecutor or her investigators, that's going to be Brady material. But they've met with Kenneth Copeland repeatedly and claimed to have no Brady material to give to us other than one or two small things that they provide us with. And they claim to have no notes, and the only reason I can think of to have no notes is so that they would not have to provide us with the content of their interviews, which is Brady material. So the whole thing is shady. I don't know another word to use for it.
It's funny that this all blew up today, because here in California, in Orange County, had a big scandal for years. I mean, you may have heard of it, Doug, because it got national attention, but involving the use of jail informants. And for years, there had been this a network of illegal jail informants who had been trained by the cops to hit up criminal defendants for incriminating information, but then it wasn't revealed to juries at all, or the defense that they were informants, that they were actually an arm of law enforcement. And we actually had there's a hearing going on in San Diego, because somebody who was a prosecutor and is now an actual sitting Superior Court judge, and was like kind of the spokesman for the DA's office, saying there's nothing to this scandal for years and years and years. It turns out that he is prosecutorial, one of the most involved in this, and he's now on the hot seat answering questions about a murder case from years ago that he didn't release information in. And one thing I was reminded of was the huge role that judges played in the revealing of the snitch scandal in Orange County. The fact that this had gone on for so long, and it wasn't until a big case landed with a particular judge and the defense raised concerns, and the judge actually said, you know what, I think there's something here. And he said, let's hold an evidentiary hearing. And so many judges before him or around him perhaps would not have done that. And it seems like we're seeing that exemplified here, because I always hear calls for an evidentiary hearing. Well, that's not as frequent as the mistrial, but Brian Steele has been calling for he hasn't used the word evidentiary hearing, but he wants to take testimony about first what was happening with Kenneth Copeland choosing to testify, the kind of back and forth on Friday that happened. But then he wanted some kind of, answers on this, and we're just not getting that. And do you see like a culture in the Fulton County Superior Court judges of like kind of taking this stuff on, or how can you kind of describe the approach to that?
I don't think I have a large enough data set to answer that with any degree of, I'm going to say, credibility. So sure. I don't have a good answer to that. Brian was seeking an evidentiary hearing today, and given the allegations that he learned of, it seems warranted. And all we're asking for is what we're constitutionally entitled to have. That's all we want. We're not looking for any more than that. And it just feels like we are obstructed um, in that effort.
I thought it was an interesting request, and also a relevant request from Ashley Merchant, who was representing Steele this afternoon. First of all, if this is a criminal proceeding, he needs some kind of a due process here, because he wasn't. It was unclear the whole time whether this was criminal or civil, because the way contempt, because the way Glanville was talking, I was assuming that it was the same kind of contempt that Woody was being held in, the civil contempt, where they're basically trying to coerce you into doing something. They're not punishing you for something you already did. It's, we're going to put you in jail until you do this thing that we want you to do. But then he made it clear that it's a criminal case. So or criminal contempt. So she raises the issue of, isn't he now a witness in this criminal case, and shouldn't he pass this on to another judge? But that didn't go anywhere either. I mean, did you have hope for that one, or can you say?
Oh, I've long ago stopped having hope.
And that's why I've said, when all these mistrial requests, I've said the attorneys have to know that he is, at this point, I mean, I think always in the beginning of trial, he was never going to grant a mistrial unless he just absolutely has to, because the number of jurors has dropped down below 12. But unless that happens, I just think it's just ride or die through all of this, no matter what. There's no, but you guys as defense counsel still have to make those mistrial motions to preserve the record for appeal. Although as Max argued today, you're not working this case for appeal. You're trying to get an acquittal as is. But
that's right. That's what's so frustrating. Yeah, we have to make these mistrial motions. And no, like you could even hear with Brian today, not expecting for them to be granted, but we have to do that. And it's so frustrating when we see things that are clearly just wrong, incorrect rulings. And all we're left with is, well, that's an appealable issue. But I don't want my client, Mr. Kendrick, sitting in jail or prison for years while this appeal drags on. He doesn't get that life back just because an appellate court sides with Mr. Kendrick or Mr. Williams or whoever. That portion of his life is still gone. So let's get it right now. Let's get it right now.
Yeah. I was thinking about that on Friday when Max asked if, before people were taken back to jail, if everybody could have a few minutes to meet with their clients, and he made it pretty obvious that I think this was going to be about just something about the fact that Kenneth Copeland was now in custody, and let's not have anything happen. But I mean, can you talk at all about how everybody's doing with this? Because we see the attorneys, and hear the attorneys, and we hear the stress going on, but you just don't hear much from the defendants about what they're going through. I mean, can you talk about that at all?
You mean what they're going through in terms of just this process?
The weight, just the process and the stress of just being in jail. I mean, has it? Is there anything you can say about that?
I mean, I can say that, Mr. Kendrick has been locked up for over 2 years. Diamante's been sitting there in the jail, and when he has that going on, when he sees the way this trial is dragging out, when there is little effort at all from the side of the state to move with any degree of efficiency, there are days that he's down, obviously. But he's in better spirits than I would be, given the situation. I mean, it's tough on the defense attorneys to go through this, but I can't even begin to imagine what Diamante's going through, sitting in that jail. It's a miserable, horrible, inhumane environment at Rice Street, and he has to sit through that, and they wake him up at the crack of dawn or before dawn to get him over to the courthouse. The food is terrible. And then you look at the case the state has against him. He's an innocent man. This process is not. It's not just.
Yeah, it's been so long, and never ending. It just seems like they're in it for the long haul. I mean, a couple people have asked me, what's going to happen? Is this just going to keep on forever? And especially a couple months ago, I was very beating the drum of, the jurors are going to drop out. It's not going to last through the summer. But you know what? Maybe the jurors will stick around. They still have a few over 12. And just the way Glanville is, if one of those jurors tries to drop out, they're going to be in big trouble. So if the jurors don't drop out, am I wrong to envision this just going on into next year? I mean, we're just going to have summer like this and a winter.
All we can do is make our best guesses, right? My best guess is we have about another year, maybe a little less than a year. I mean, the state still has well over 100 witnesses to present.
Wow.
I mean, there's a second murder in this case that hasn't been tried before, even after the Donovan Thomas murder. There's scores of overt acts to go through. There's no end in sight right now. I mean, maybe it won't go to 2027, like I said in my motion, but at this point, because they've cut the number of witnesses down, but we're going to be well into 2025.
Yeah. And in terms of Glanville's ability to halt that, I mean, is he a bit constrained in what he can actually do to their case? I mean, he could speed things along a lot more. He could start on time, but I mean, at this point in the case, he can't just throw out charges, right? I mean, it's up to the prosecutors whether they want to bring this stuff. I mean, he was making that point with Kenneth Copeland where, I mean, yeah, he can grant a motion to quash a subpoena, but the grounds for that are, the subpoena's harassing. It has no relevance or whatsoever. But if the prosecutors are charging stuff like this and they want to bring people, they can, right? I mean, it's pretty much up to them.
Well, if you go back and look at the motion I filed in March to try to get this case moving, and there is plenty of case law that says he can put a time limit on the state. So, if he wanted to, he could put a time limit on the state's case in chief. He has elected to not do that, but I provided plenty of case law where he's permitted to do that. But he rejected that, so it's clear that is not going to happen.
Yeah.
And the state is going to be allowed to call these witnesses. And I'm kind of run out of options for what to do to move this case along at an efficient clip.
And I'm sure this is something that Brian Steele's lawyers and all his volunteer defense team is looking at right now. But is there something to be said about, I mean, everyone was agreeing. I mean, even the prosecutors were saying, we want him here in trial. And like you said, their motive isn't to be nice to Brian. They don't want their case getting screwed up. But it's got to be tough to actually be a lawyer and work on a case when you're in jail. I mean, he asked if he could be cellmates with young thugs so they can work on the case together. But is he going to be able to bring papers and notebooks into his cell like that? I mean, what are the conditions he's going to be under in there?
I don't know, but I mean, I know that our clients that are in jail are allowed to have papers, but the problem is this case has 8 terabytes of discovery. So, the only practical way to deal with that is electronically for the most part. I mean, of course you print out certain things, but you need computer monitors, you need a computer, you need a 8 terabyte hard drive, and I don't think they're going to provide that to him. Who knows? I don't see how you can effectively I don't see how you can defend your client without significant handicap from inside of a jail. And you're going to take away all of his weekends. That's not a good situation to be in.
Yeah, and not being a practicing attorney, I'm in a position where I can be a little more liberal in my comments about sitting judges and stuff. But it just seems like Glanville obviously has a short fuse, and he really does not think stuff through very much. I loved how the Washington Post described him as a joyful disciplinarian. I thought that was pretty accurate. But it's like, yeah, on the one hand, he's saying everyone needs to take a deep breath, recharge, relax, kind of giving you guys the kumbaya peace talk. And then he's like, well, I'll go spend the next, 10 weekends in jail. It's like, okay, I don't think this is going to help here. But
well, let me ask you this. I'm going to ask you a question.
Yeah.
As someone who's just witnessing this and maybe has better perspective, far better perspective than I have. All the both sidisms that we get from the bench, do you see behavior constantly from both sides that needs to be reprimanded and reminded of our professional responsibilities?
No, not constantly. I do see some like the defense is, I think you guys might be, reaching a little bit or whatever, but there's such a distinction between the defense and the prosecution. And I saw something in another case. It was a federal case here, completely unrelated to this, but the judge made the distinction between advocacy by the defense and advocacy by the prosecution. He said it's basically the defense's job to throw stuff at the wall and see what sticks for their client, because they want to make any argument that could possibly help their client. Whereas the state, representing the state's interests in prosecuting crimes, you would expect to take a different role and have more of a coherent narrative that they stick to. And they're not just changing their story, changing this, doing this to try to make it work. And I see the prosecutors as doing that more here. Whereas, and I don't see it as being like extreme on the defense side, but like I said, that's basically your guys' role, is to do that kind of advocacy. And I feel like the DA's office confuses that. And it's almost like their private counsel. And I saw somebody on a TikTok clip of DA Love talking, and they're like, wow, for the first minute, I thought this was a defense attorney talking. And that's it. She approaches advocacy from like that kind of standpoint. And it's like a little unbecoming of a prosecutor to have somebody doing that.
Well, there's no doubt that she is tenacious and a bulldog in the courtroom, and quite the advocate for the state. I don't know what to say about her anymore. I really don't. Individually, when she's a perfectly nice person to talk to.
One thing, and we had chatted about this, because I get there's just so much sexism everywhere. But the people who leave comments on videos of her saying like, oh, she and Glanville must be sleeping together. It's like, you're really not doing yourself any favors, because I do sense some defensiveness from her. And I can imagine that she sees those comments and it just feeds her defensiveness, because she sees that stuff and she's like, wow, the people who are criticizing me are sexist pigs, because that is a sexist thing to say.
They are. Those comments.
You don't think
ridiculous. Those comments are sexist. They're misogynistic. There's no basis for them, and they really don't even merit speaking to, but they should be thoroughly condemned. I have no love in my heart for ADA Love, but to allege that she and the judge have some type of inappropriate relationship is completely out of bounds and without any merit whatsoever.
No, exactly. I need to start scrubbing those comments and just ignoring them for sure. But it's like the people who I think it's much more worthwhile to try to focus on what her actions are actually like, and try to argue, what's actually going on in the case and how this is affecting justice in the end. I think she was using the word ad hominem in court wrong the other day, but these attacks that people are making on the internet against her and the judge are pure ad hominem attacks. That's a good example. Those are ad hominem attacks. When Brian Steele is just criticizing her for like something that she told the judge in court, it's like, okay, that is not a personal attack. Like, no. I mean, but then Brian Steele's been practicing in Georgia forever. To repeatedly call him a liar in open court is offensive to anyone that knows Brian and his integrity that is well earned over his decades of practice. Brian Steele does not lie in court. Brian Steele does not lie to the judge. He's such a good, God forbid.
Call him a liar. I've run out of words other than outrageous in this trial. Brian Steele is not a liar. And it's unprofessional to call him one in court.
He's so earnest about everything. You know, he's just such a defense attorney at heart. Yeah, and actually, I should send him an email and tell him this. But God, was it Friedman or John? So a criminal defense attorney who practices in federal court here in Los Angeles did a case with him years ago and follows my coverage and was like, he's exactly the same. He still looks the same. He sounds the same. Like, but he's always like commanded like a lot of respect from co-counsel. That, I mean, he's earned his reputation for good reason, you know.
It's not just that he's a zealous advocate as a criminal defense attorney. He is a true believer in our justice system. And I'm not going to speak for Brian Steele, but, you know, it must break his heart to see what's happening in this case at times.
I liked Thugger Daily, who we all follow on Twitter, posted that clip of him talking about how he doesn't like to come to work anymore, and like included a couple broken hearts after it. It's like, yeah, seriously, what a bummer. But the whole case is just such a drain on everybody. You know, how can you guys get through this? But it just seems like it just got all the more stressful. And now, and perhaps you're not in a position to talk about this, but with this being a criminal contempt, I mean, this is done. It's not going to be like it was with Woody, where, you know, Glanville's going to give Brian Steele another chance to say who told him this, right? It's just the book is closed. It's over. He wouldn't tell him who told him that, so he's held in contempt. Or is there, and not that Brian would, but would he?
I'm not really going to speak to that. I mean,
sure.
The judge I don't know. The judge, you can watch the clip, see what the judge said from the bench. I believe that he said that basically Brian has the keys to the jail cell and can get out anytime he wants if he gives the name. But again, I hate this whole focus on Brian and whether or not he's providing the judge with the name, because it distracts from the underlying issue
of this
ex-party communication.
Everyone agrees. I mean, Rafi, I forget his last name, but he does a lot of federal appeals in the Fifth Circuit, but he's big on Twitter. I saw that he kind of caught wind of this, and he's like, I don't know anything about this case, but he's like, how would an ex-party meeting like that between judge and prosecutors not just like end this trial like right now? It's like, well, when the judge who is the one who had the meeting with the prosecutors is the one who's to decide whether that ends the trial or not, like it just doesn't pan out. But it just seems like there's a lot of shock amongst attorneys that this would be even happening. But Glanville seemed to be pretty, I don't know if smug's the right word, but solid on the fact that, you know, he had the court reporter there and the appellate court can just deal with this, right? Like,
well, that's a rather, if that's his attitude, it's a rather flippant attitude. Yeah. We have people's lives on the line and we're trying to defend them, and we need to cross-examine it. We need to cross-examine Mr. Copeland. And there are things that may have come up that are relevant to that cross-examination, and we're not going to be provided with that. So, and we're going to have to rely on the proffers of Miss Love, ADA Love.
What is the transcript situation? I take it you guys aren't getting same-day transcripts. What's the turnaround that you usually get for transcripts?
The judge is not going to provide us with this transcript.
Oh, he's going to keep it sealed, huh?
That is the impression I get from everything he said from the bench today.
Oh, wow.
That he has no plans to give us this transcript. He said something from the bench to the effect of, well, the appellate court will have that transcript. And I guess they can review his conduct and the conduct of the prosecutor in chambers. But we need that transcript.
Yeah, because like you said, it has to do with just for the cross-examination. And then there's been some, I mean, Brian Steele even said on the record that there was some kind of, you know, they thought that Woody had implicated himself in some things or something. And that would all be Brady material for your guys's, like we said
exactly.
earlier.
Exactly.
Exculpatory evidence.
And we've heard it's what Keith Adams said, and it was hard to hear him, I know, in the video, but you know, if even a portion of what we learned is true today, that needs to be there needs to be a hearing on that. We need to understand what happened, because even if a portion is true, that directly implicates the testimony of Mr. Copeland.
Yeah, yeah. And I was just thinking about Copeland's huge role in the case. I mean, Brian Steele talked about it last week when he was just talking about the pivotal, how important his testimony is. But I mean, Brian Steele opened with him that he was the real killer of Donovan Thomas. But it seems like that's the thing. If you just think about my memory, think about the poor jurors, like they remember any of this stuff. But was he one of the ones at the mall? Is that the terroristic threats charge that he had? Was he at the mall with Young Thug on the?
You mean at Perimeter Mall in Dunwoody? Was he
Yeah,
there?
was he involved in that?
I don't recall if he was there. I want to say no, but you're really taxing my memory because that was months ago that came up in court,
Yeah.
and that's been flushed from my brain as new things have come in. So I'm not sure if he was there, but
Somebody in the comments
Copeland,
says he wasn't.
Copeland is absolutely central to the prosecution's case.
Yeah, they were kind of freaking out. You could tell about. I mean, it just seems like Glanville's decision to have this secret. I mean, maybe secret's not the right word because it technically was on the record, but it was pretty
secret from us.
Yeah, pretty secret at the time. It has to stem from what Love was accusing, pretty serious accusations against Woody's lawyer on Friday, basically saying that he was like a plant for the defense team.
Oh, another completely outrageous statement.
Yeah.
Again, I'm out of words. There's absolutely no collusion between Copeland's attorney and any of the defense attorneys. There's nothing there.
So Bumpus, who appeared for Woody today, was Melnick's replacement because Melnick had plane tickets or something.
Yeah.
Right? And then the rest of what happened is like kind of what we're dealing with right now. We don't know. We just know what Brian Steele said in court, and then was promptly shut up through the "Who told you that?" He won't reveal his sources. He won't reveal his deep throat. Too bad there's no lawyer shield law because for a reporter, I mean, it's just different because Brian is an advocate. So, he's using, as he should, he's using any information he can to advocate for his client, but there's no shield law that protects him from.
Well, I mean,
having to reveal anonymous sources. But there must be something else. I have to listen to Ashley's argument a little bit more in detail tonight, but it seems like, first of all, she completely schooled Glanville on the civil versus criminal contempt. But it seems like we're going to be. I'm looking forward to reading the filings for the appeal in the next couple days.
Yeah. And Rule 1.6 does require attorneys to hold communication with the client privileged. So depending on, Brian was asserting Rule 1.6 as one of the reasons that he could not divulge his source of information. And I'm sure that's going to end up being heavily litigated in this situation. But,
and was that attorney-client privilege?
Yeah, it's attorney-client
Well, because
privilege.
that's what I was thinking, because Glanville was saying, well, there's no way this could be attorney-client privilege. It's like, well, theoretically, Young Thug could have heard this from somebody, and then he went and told Brian Steele. So it would be attorney-client privilege if he heard it from Young Thug, but I don't know.
Yeah, I'm sure it'll all come out. I'm sorry, but I have to run because I have to do a filing.
Sure. Hey, thank you so much for joining us, Doug. We really appreciate it.
Yeah, it's good to talk to you, and thank you for all your coverage of this, because I think it's very important that all this get out to the public, what's going on in that courtroom.
Yeah, no, it's important. We'll watch some more clips here. So have a great night. Thank you so much. See you on the stream tomorrow. All right, that was cool that he joined us. It's cool that they're all so open. I gotta try to get Max Shard on here or something, or the man himself, Brian Steele. But they're all so busy with different stuff. Yeah, it was little Woody's attorney that told Brian. Probably, yeah, not a bad guess for sure. Yeah, so let me see here. I wanted to bring up, do I have that clip yet of the actual pronouncement, the sentencing pronouncement for what he got? Because gosh, they were there in Atlanta until 7 p.m. last night, or tonight after 7 p.m. Pull this up on the old Twitter. As you guys can see, I post most everything on Twitter, or not Twitter, but TikTok and YouTube. Not as much on Twitter. Thugger Daly's the guy to follow on Twitter, but got this clip on here.
The incarcerated in the Fulton County Jail for no more than 20 days for this contempt. Those 20 days consisting of every weekend for the next 10 weekends. And you'll be reporting to 901 Wright Street Northwest, Atlanta, Georgia, 30318 at 7 p.m. on Fridays. You'll be released on 7 p.m. on Sundays. And it's to commence this Friday, June the 14th at 7 p.m. and not to end until Sunday, August the 18th at 2024, 7 p.m., subject to further order of this court. And that will be entered and e-filed. You may take whatever steps you and your counsel deem appropriate after that. Okay?
Can I ask a question?
Sure.
I'm going to file a notice of appeal, but for whatever reason that doesn't take, and you don't give a bond, then I'd ask that I can be with Mr. Williams and we work on our case all weekend, for all those weekends. Otherwise, I can't prepare. I speak with Mr. Williams all the time.
That's up to you. And sir, I will, sir, if that comes to pass, you have my support. I will talk with our sheriff and we may be able to make that work. Okay. If that should occur. Okay. All right. Okay. All right. All right. Is Miss Counsels, I'm done with this unless you have anything else. All right. Thank you. Thank you, Miss. Thank you, Miss Merchant and Mr. Sisser.
Thank you.
Okay. All right.
Did we get a copy of that?
Yes. In fact, the clerk is going to file a copy. It's going to be e-filed. It'll be on the e-file system momentarily. You should be able to get a copy of it from there, directly download from there.
And Judge, Ms. Merchant and I will file entries of appearance on behalf of Mr. Steele.
Sure. That.
Here.
Mr. Steele, in the interest of your representation, continued representation of Mr. Williams.
So this is after the initial take him into custody. Glanville is such a hothead, joyful disciplinarian, take him into custody. And then Love raises I still need to post some of these clips. Love raises the issue of, and as Doug Weinstein said, she was not doing this to be nice to Brian Steele. She's doing it because she knew losing Brian, like as an attorney, would slow down the whole case. But she made the case of, can you fashion a remedy so that Brian Steele can still be Thug's lawyer during the trial? So Glanville was like, oh yeah, I think you're right. So this is him. He said, tell Steele he can put his tie back on, which is like kind of a flip. And this is a pretty serious issue. He's kind of being kind of jokesy about it, but this is him like calling Steele back in and explaining what's going on.
Is been brought to court suggestion that you be here until when we've at all open sessions of court and until we finish for the day. So I'm still going to hold you in contempt. You can purge that contempt by just telling me who it is that told you this information. That's all I need to know. But at the end of today, I'll ask you that question again today. We did not take up any business in your absence, other than Mr. Adams eloquently saying that he was not going to go forward without having you present with him. So, and him not wanting to divulge who the information came from either. So, with that, sir, we're going to go ahead and continue. All right.
Ask a question.
Yes, sir.
Did the court order the transcript that we can see it and have a hearing and call witnesses?
No, I'm not gonna order the transcript as of yet, because if the case should be reviewed, the appellate court will have that particular ability to do that. I don't believe at this point in time it is the court's understanding of the ex parte conversation that the disclosure is the more troublesome remedy. If I did something wrong, then certainly that can be reviewed, but I'm not at this point in time going to release any of the transcript in terms of what may be disclosed or that was said in Chambers ex parte at this point?
Well, I was told based upon information belief that it would affect his witnesses' testimony from the jury, because I was told based upon information belief that depending upon how the day goes, he may go home or not, depending upon his testimony. I'd like to know what that's about.
I don't know, Mr. Steele. I don't know. I mean, that's why I would like to know who it is that told you or disclosed this information from Chambers, because I don't know if this person even had, if that conversation was even had within my presence or hearing. I don't.
So I would like to have a hearing, the court as a witness, with Diaz as a witness, with the deputies as a witness, with Mr. Copeland as a witness, with his counsel as a witness, court reporter, transcript. And Judge, I'm not trying to be harmful.
Mr. Steele, I think that you're running a very thin professional responsibility line. I don't think you have cover at this point in time. I think you're blowing your coverage at this point, because I do think that somebody told you some things that violate privilege.
What privilege?
Attorney-client privilege. So, I mean, but that's beside the point at this point in time. We're not going to argue about that right now. I just need the way you purge your contempt is that you just tell me who told you this. I'm not asking you what was said. But you're indicating what was said. I want to know who told it to you.
And I'm making it based upon information.
But I need to know who it is, because that's critical for the court taking remedial steps at this point in time.
You're holding me in contempt.
No. Yeah, I'm holding you in contempt because you won't tell me who.
How could something, I'm not trying to be obstruction, but how could something be attorney-client privilege and happen before the court?
Well, because if somebody's a represented party and they disclose the information that to you all as parties in this case, that could be a problem. That could be a problem.
I don't.
I mean, like I said, I don't know what was said to you. I don't. So
I'm trying to get out.
Well, that's improper at this point in time.
Why?
Because you are telling the court conversations that you are privy to in my chambers that I know you weren't present.
But the court was present. That's what I'm trying to say.
That doesn't make a difference, but you got information that you shouldn't have had. And then you can't, and then you turn around and you say, well, the court did something wrong and that we should be entitled to have the transcript. You all have contorted and perverted that particular process. You really have.
What I said was it is a material part of trial.
It's not, well.
Has a right to be at, and I'd like to exercise.
It would be just like if you all in the past have had ex parte conversations with the court. And I won't say about for what. You and Mr. Adams and others. That is your right. And that little period or that little conclave of discussion with the court protects you and protects the system. It's recorded and taken down. So if it needs to be reviewed later, it gets reviewed. But you have made something out of it that where I'm kind of at a disadvantage at this point in time. So, because I didn't invite you into that particular proceeding, and I don't think you had a right to be there.
Well, all I know is what I told you, and there's more.
Okay, well.
So witness testifying who met with the court and the DAs, that doesn't concern us?
Your Honor,
Meaning the defense?
I think that for an ex parte conversation, in terms of what was said, and I'm not gonna continue to discuss this because the transcript is what the transcript is, and it will say what it reflects. It really will, and the court will stand by that. But the other conversations that you may be privy to or may have been disclosed to you, they're troubling. They are. That's why I've got to find out who it is that disclosed that information. So you have the keys to your own contempt. I don't want to hold you in contempt, sir. I don't. I'm not asking you to tell me what was said between the two of you, but I do need to know who told you. So
Weird logic.
if you're willing to tell me that, that's fine. that will purge your contempt. If you don't want to, then, you know, I'll unfortunately have to look at and waiting to get that information. So you can let me know.
Did the court put this in order?
In terms of what, sir?
I suppose contempt.
It's criminal contempt. It's sua sponte criminal contempt, sir. You don't get to appeal from this. You will go into custody at 5 o'clock today or whenever we finish if you don't tell me what that is. Tell me who that is. This is criminal contempt. I have asked you a question related to these particular proceedings, and if you don't tell me, then you'll suffer the consequences of that.
Okay, obviously, we saw the clips after this. Steele did not go into custody at 5 p.m. today. He's supposed to go report to jail at 7 p.m. on Friday, and he's going to be released Sunday at 7 p.m., and he's supposed to do that every weekend for 10 weekends. But as you guys heard Doug Weinstein just say, I mean, you guys heard Glanville just now. He was really adamant that he can't appeal this, but they've already filed the notice of appeal. Steele's wife, who's actually his law partner too, filed it this afternoon, and she filed a motion for bond too. And let's finish the clip here, and I'll. Judge Glanville has the order in for contempt on him.
Unfortunately, like I said, I'm not looking to hold you in contempt. I really am. I'm not. But this is that important.
Important is important.
Okay. All right. So you got think about it. All right.
Can I just, last thing, going forward, is over objection, because I believe that we're entitled to these information, especially with this witness.
All right, sir. I'll note your objection. It'll be a continuing objection for the time being. And I may make some other remedies depending upon what information I find later. Okay? All right.
On behalf of Mr. Stillwell, I'm going to review our Brady demand for any Brady material
Yes, sir.
that came out from any conversations with Mr. Copeland, between Mr. Copeland and the district
Yes, sir.
attorney's office this morning.
All right. Summon our jurors, please.
Okay, so like we talked about with Doug Weinstein, when Max Shard said Brady material, he's referring to us Brady versus Maryland. It's a U.S. Supreme Court case that says anything that could be considered exculpatory to the defense and the prosecution comes across it, it's in their possession, they need to hand it over. So stuff that Woody said in this meeting, this chambers meeting that they had, could be Brady material. And Steele said this morning that he'd heard that he'd confessed, that basically he confessed to killing Donovan Thomas. So if that is true, that's definitely Brady material, but it's a question of whether that's going to be released or not. And if there's going to be any kind of transcript released before the cross-examination begins, which probably won't be tomorrow, but it could be. It could be tomorrow afternoon that they're up for cross. But like Doug Weinstein, who was with us earlier, Yak Gotti's lawyer, was saying, it doesn't sound like Glanville is going to let that transcript be released anytime soon. So it's just kind of a question of what's going on with that. But obviously all this drama kind of overshadowed the testimony that we heard from Woody today. And we didn't hear all that much from him, but he did identify Shannon Stillwell in the courtroom, although he didn't really say much, and talked about, went through some photos with Simone Hilton, but I can bring up the beginning of his testimony here.
I gotta say it back.
You haven't said anything yet. On Friday, when we left, I asked you how old you are. You said that you were grown. Can you please tell us how old you are?
Say that again.
Sure. Can you please tell the jury how old you are?
Uh, 32.
And when is your birthday?
Say that again.
When is your birthday? Sorry. When is your birthday?
Next month.
Is that July?
I think so.
Okay. And were you born on July 25th?
I guess.
Okay. Are you from Atlanta?
I'm from Canterville.
Okay. Is that a section of the city in Atlanta?
I guess.
You guess. All right. And did you grow up in Mechanicsville?
For sure.
Did you say for sure? All right. And when you grew up, do you have siblings?
Huh?
Do you have brothers and sisters?
Yeah.
And when you were younger, did you live with all of your brothers and sisters?
Overruled, sir.
Yeah.
Okay. I want to specifically talk about your brothers. How many brothers do you have?
Overruled, sir.
More than one.
Okay. How many?
I think 3.
All right. And what are your 3 brothers' names?
Overruled, sir.
Trey Nato boss.
Say that one more time. You said it's fast.
Nato Trey's boss.
Nato, Trez, and Boss. Okay. Nato. What's Nato's given name? Or you just give me the first name.
I just did.
Nato.
Yeah.
Okay. Trez. What's Trez's first name?
Trey's.
Is Trez's first name Ron Trez?
I guess.
All right. And Nato, is that Rodney?
I guess.
Okay. And then what's the third nickname you gave me?
Boss.
Is Boss Rodriguez?
I guess.
All right. And when you were younger, did you go to school?
Yes.
Where did you attend school?
I don't know. I went to a lot of different schools.
Okay. What are all the schools you went to?
I don't recall all of them.
Oh, just tell me something.
I only know one. Slater.
Slater. Is that elementary school or middle school?
Elementary.
Why you don't remember what middle school you went to? Did you go to middle school?
I think I did.
How long did you go to? Did you finish middle school?
Overruled.
Yeah, I think.
Okay. Did you go to high school at all?
Yeah.
All right. When you went to high school, did you go to Southside?
Yeah.
Yeah.
Overruled, sir.
Did you graduate from high school?
No.
All right. Do you remember what year you left high school?
No.
All right. After high school, did you work?
No.
What did you do after high school if you weren't working?
Say that again.
Did you do anything? If you weren't working, what were you doing?
I don't recall.
Okay. Are you married?
Nope.
Are you in a relationship?
Nope.
Do you have children?
You know that.
Okay. I do, but the jury doesn't. Do you have children?
Yep.
All right. How many?
More than one.
All right. Do you have more than 3?
I might. Ain't no telling.
Okay. That's perfect. That's fair. Do you have 2 that you know of?
Yeah.
All right. And how old are your 2 children?
The same age.
What's that?
I don't know. Y'all been having me in jail so long. I can't recall.
Okay. Were you in jail on Friday? Prior to?
Yeah, I was in jail Friday.
Were you in jail on Thursday?
Thursday ain't came yet.
No, last Thursday.
I felt like it.
All right. When you were in jail last Thursday, although you felt like it, how old were your children?
I don't know the ages.
Okay. Are you currently working?
I'm in jail.
Prior to going to jail on Friday,
Are you currently working?
Nope.
All right. Now, you talked about being in jail, which was on Friday. Prior to any of this, do you have any criminal conviction?
Of course.
Okay. Do you know offhand how many?
Don't keep up with it.
Okay. Tell the jurors the types of crimes that you've been convicted of.
Driving without license.
Okay. What else?
It's not bad.
Driving with suspended license.
Okay. What else?
Ran in front of police.
All right. What else? Let me ask, do you have a theft?
I'll be putting charges on me, so I go to jail for the charges y'all throw on me.
Okay. Do you have a conviction for theft by taking?
You tell me?
Do you recall having a conviction for theft by taking from 2009?
What did I take?
Yes or no?
I don't know what happened in 2009.
Do you recall having any convictions for aggravated assault?
Probably so.
All right. What about conviction for entering auto?
I don't know.
Okay. What about for terroristic threats?
What about it?
Do you have a conviction for terroristic threats?
I think it was with the aggravated assault.
Okay. What about theft by receiving stolen property?
I don't know.
What about possession of a vehicle with altered VIN number?
Never heard of that.
Okay. And what about possession of a controlled substance with the intent to distribute?
What's that?
Did you ever take a drug charge recently?
Oh, that's the charge y'all put on me.
Okay. Did you plead guilty to that?
I had to.
All right. And did you recently plead guilty to possession of a firearm by a convicted felon?
Y'all put that charge on me too.
Okay. And did you plead guilty to that?
I had to.
All right. Your Honor, the state's going to tender State's Exhibit 382Y, 383Y, 384Y, and 385. Thank you, Your Honor, as self-authenticating documents.
Yeah, I see somebody said they've fallen asleep on several videos. The state is very long-winded. Yeah, and I was just thinking, if I have time when I put together these videos, and this is the kind of thing that I would try to cut out. Just cut it out and do a little transition blur so you get right into the stuff. And if you have time and go through an exam and do that, you realize how much time they waste. It's like, seriously, yeah, they're very long-winded, and then it just takes them forever to go through these exhibits. It's like fucking, and the trials that I watch, like in LA, especially like LA federal court, they are not like that. And I never understand why they're supposed to release these exhibits and everything beforehand, and the defense is, supposed to get all this stuff beforehand. But then, like in the middle of trial with the witness on the stand, they'll be like, "Oh, these are the exhibits we're going to go over," and all the attorneys come over and look at them, and it takes like seriously 4 or 5 minutes, like for one batch of exhibits. It just takes forever, But let's see how this ends here. It's just so slow going. It's no wonder he's going to be on the stand for so many days, because, I mean, we even really heard anything about Donovan Thomas. It was kind of his background, his criminal history. They went through photos of him and Demikion Garland. I got to go through some other clips here, but we'll finish this one off.
382Y is the criminal conviction, 15 SC.
Yeah,
Sure.
I'm getting to that, Mr. Steele, so.
Yeah, she ends here. Yeah. But yeah, that was Woody. Like I said, not anything too big from Woody today, but I've still got to go on the clips. And yes, Woody is out. Woody's getting out of jail. I have that clip on TikTok, but I've still got to get it up on YouTube. But Glanville signed an order of release today. Here, I'll bring it up. I've got it on Twitter. He signed an order of incarceration for Brian Steele and a release order for Woody. But Woody agreed to come back to testify tomorrow, so he's supposed to get out of jail tonight. Hereby ordered that upon receipt of this order, the Fulton County Sheriff shall instant or what? Release said witness instantaneously. I'm going to read it like that. Said witness from the custody of the Fulton County Sheriff. So there you go. And then I tweeted Brian Steele's order of incarceration, order of contempt and incarceration for Brian Steele. There you go. What a day in court. I think I'm going to wrap it up here, guys. I got to post some more clips for you guys, but I want to keep doing this. I might do another recap tomorrow afternoon, tomorrow evening or something, depending on how things go. But we have a lot to go over, and I want to follow the appeal of Brian Steele's contempt order, because right now he's supposed to go to jail at 7 p.m. on Friday. So we'll see how that actually goes. But shout out to the replay crew. I gotta advertise the Doug Weinstein interview a little bit better, because that was a good one to have. I might cut that out and posted it as its own video. But thank you guys so much for tuning in. Check out my channel. Give me a subscription for check out all the videos I post. And I'm also on TikTok, sharing a lot of clips on there if you're in there. But everyone, Petals Ferry, I like your name. Thanks for saying hi. And I'll see you guys later. Yeah, John Balkan, it was great that Doug could join us. We'll try to get him on there more. And, maybe we can get Max Shard or somebody on there, the man himself, Brian Steele. But I will see you guys later. See you guys.